All right, good afternoon once again. Welcome back to the 28th Circuit Court here in Wexford County. We're next taking up the case of People of the State of Michigan versus, Christopher Perkins. I chuckled because in my head sounded like my introduction, and it reminded me of Mutual of Omaha. Remember that guy, and his name was Perkins. Disregard. All right, thank you very much. We're here today for a pretrial conference, and it looks like we have a resolution of the case. I'm going to start with appearances from counsel.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you.
Thank you, Your Honor. Taylor and Anna Credential on behalf of Mr. Perkins, who joins me at council table.
Mr. Perkins is here currently in pretrial custody. Again, we're here today for a pretrial conference. I've been told that the parties have met, and they have told my staff that we have a pretrial agreement. It looks like the defendant, who is currently charged with 2 counts of failing to pay child support, will plead guilty to both of those as charged, and the benefit to him is that the prosecution will agree to no upfront jail, which means at the time of sentencing. And of course, we'll talk about whether or not about bond and so forth. So, Ms. Williams, is that correct?
That is correct, Your Honor.
Mr. Vento?
That is correct, Your Honor.
All right, Mr. Perkins, have you heard what they've told me?
Yes, sir.
Is that how you wish to resolve it?
Yes, sir.
To the best that you can, sir, please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Perkins, looking back here at one moment. There's a date range. In 2020, 2021, and 2022, were you on probation or parole at that time anywhere?
Yes, sir.
Were you on bond pending any felony charges other than this stuff?
No, sir.
So you are currently charged today on this felony information with 2 counts. Each count asserts the same charge over a different set of dates. Count 1 alleges a charge of failing to pay child support, covering a date range of October 1st, 2020 through December 31st, 2021. And that is a felony punishable by up to 4 years and or up to $2,000. Count 2 is a similar charge, again, failure to pay child support. That one covers a date range of January 1st of 2022 through December 31st, 2022. And again, that is a felony punishable by up to 4 years and or up to $2,000. Told here also that at least as the time of back just before this was filed, as of November 1st of 2024, you had accumulated arrears in the amount of $27,476.13. I'm told today that you're going to plead guilty to those 2 charges.
Yes, sir.
Now, you might be wondering, what's my benefit? Well, it sounds like the benefit here is what the attorneys have reached into an agreement regarding the sentence. So if I take this plea today and I accept it and find that you're guilty, we'll be back here in about 4, maybe 5 weeks to set a sentence. Now, whether or not we deal with a modification of bond, which depends upon the paying of the quarter amount, I'll deal with that a little bit, but that's not relevant yet. Told that at the time of sentencing, there's what we call a killer agreement. Now, they don't talk about that. The attorneys didn't use that language on this written agreement, but I need to talk about it. There are different types of agreements for sentencing. I don't do. One of them is called a Cobb's agreement, where today I would agree right now as to no additional jail. I don't do those for a very specific reason. That reason is I don't know anything about you. I don't think I've ever seen you before. If I have, I apologize that I don't remember. But I don't like to commit myself until I know more about a person. I don't know about prior criminal history. I don't know how well you've done on bond or probation. I don't know where you work and whether or not you're wanted for something in Brazil. I got no idea. I'm just making stuff up. But the point is, I don't know anything about you. So what this agreement is, it's called the Killebrew Agreement. Now that name Killebrew is just the name of an appellate case, and it says this: if at the time of sentencing I do not go along with it, yes?
Your Honor, this isn't a Killebrew agreement.
Okay, and then what is it?
It's just a agreed upon recommendation, but it's not as a sentence agreement or Killebrew.
Oh, okay. Well, hold on. Let me finish that. I didn't understand. So now I understand why they didn't put it out. And maybe I should have put my glasses on. Oh, it does say recommendation. Technically, I should say the X is not in the box, but that's okay. So we're all wrong. What I'm trying to do is make myself better. No worries. But a Killebrew agreement would be that if at the time of sentencing I did give you jail, you would have the right to withdraw your plea and come back to this stage of proceedings. Now, in this instance, it's not a Cobb's agreement or a Killebrew agreement. It's something even a bit softer. That is that the prosecutor agrees that she will recommend to me that I don't give you any additional jail. That I put you, which means I'd be putting you on probation, giving you time to make the payments. Does that make sense?
Yes,
So far, is that what you thought you were doing today?
sir.
Great. Ms. Williams, did I get that right?
Yes, Your Honor.
Thank you. And Ms. Spiravento?
Yes, Your
And
Honor.
thank you for standing up. And thank you for not saying, hey, Judge, you're an idiot. You didn't see the X. All right. So, sir, I'm going to hold up this document that says pretrial agreements, 2 pages long. And over here on this side, it looks like it's got your signature right over here. Did you go over this document and sign it?
Yes, sir.
Now, have you talked to Mr. Bento about this pretrial agreement?
Yes, sir.
And has she gone over the law and the facts of the case with you?
Yes, sir.
Has she given you advice about how to handle cases, what you could do, what the possible consequences are and things like that?
Yes, sir.
And have you been satisfied with her representation up until this moment? All right, so we're going to put that over there. Now, if we enter these pleas today, you're not going to have a trial. Does that make sense? Now, this next document that I'm holding up says at the top advice of rights, and it lists several rights here, like right to a jury trial, things like that. And then it appears to have your signature. Is that your signature?
Yes, sir.
Now, did you read through all these rights on this page before you signed?
Yes, sir.
Did you understand the words that you read?
Yes, sir.
And again, even more importantly, you understand that if you enter a plea of guilty today, and I accept that plea, you will be forever waiving these rights as they apply to this particular case.
Yes, sir.
You also will be waiving the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Have there been any other promises, threats, inducements, force, coercion to make you plead?
No, sir.
Are you making this plea of your own free choice?
Yes, sir.
Now, I trust that Ms. Fiorvento has talked to you about potential sentencing. She's probably talked to you about the Michigan sentencing guidelines and how they give recommendations as a sentence. That is merely a recommendation. The sentencing guidelines are not mandatory upon the court. However, they are a tool the courts must consider, but the results are not mandatory. Has anyone made any promises to you or suggestions to lead you to believe exactly what I'm going to do for sentence?
Yes, sir.
Good, because I don't know, because I don't know you. And except in case I do, I apologize. In case I've seen you. Have you ever been here before?
No, sir.
Great. Well, that's a good thing. So, do you have any questions about this?
No, sir.
Do you believe, at least while it may not be the greatest thing you're going to do you believe that taking this plea today is going to be in your best interest?
Yes, sir.
All right, thank you. As to the 2 counts, sir, how do you plead?
Guilty.
Before I can accept that plea, I'm going to ask you some questions, and you're going to tell me what it is that you did that makes you guilty of these 2 offenses. So just bear on here, and I'll bear along with me, and I'll get through it. We're going to turn our attention to those 2 dates. Again, do these involve just a single child, Ms. Fiorvento?
2. Just one child, Your Honor.
Just one child. All right. Ms. Williams, is that correct?
1 second, Your Honor.
Sorry, I just wanted to ask you a question to make sure you were paying attention. Just, I know you were.
I'm here, Your Honor, yes.
All right, so Mr. Perkins, you have a child that a court ordered you to pay child support for, is that right?
Yes, sir.
And is that child still under the age of 18 now?
No, sir.
Okay, so I want to look back at this period of time here. Looking back for count one, between October 1st of 2020 until December 31st of 2021, was that order to pay child support still active?
Yes, sir.
And it looks like you were living out in Texas. Does the child live here in the city of Cadillac?
Yes, sir.
And that's here in Wexford County? You agree? And so for that period of time, you failed to pay all of those payments that were ordered by that court for that child. Is that correct?
Yes, sir.
As to count two, looking back at the state range of January 1st of 2022 through December 31st, 2022, at that time, was your child still under the age of 18?
Yes, sir.
And were you still responsible for paying for the child support?
Yes, sir.
And during that period of time, is it true that you failed to make those payments?
Yes, sir.
Thank you. All right. Ms. Williams, you believe the defense provided a factual basis?
Yes, Your Honor.
And are you aware of any other promises, threats, and inducements?
No, Your Honor.
And you believe the court is in compliance with Mission Control 6.302?
Yes, Your Honor.
Ms. Ferravento, do you agree with all three?
Yes, Your Honor.
Got it. All right, the court agrees and finds the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfied the required elements of proof for each of the two counts. Therefore, the defendant is found guilty of counts 1 and 2. Mr. Perkins, the way it works here in Michigan is anytime someone is convicted of a felony within a state court, a report must be prepared by the Michigan Department of Corrections, and they're also known as the Probation and Parole Office. Now, this report is called a pre-sentence investigation report. It will include a description of the offenses, description of the pre-trial agreements, statements, information you may provide while it's being prepared, and also information about any prior criminal history, if you have any, as well as how you performed on probation, bond, and things like that. Now, there are three, it will also include a scoring of the guidelines. These guidelines are required to be calculated by the legislature, but your result is not mandatory. What those do is they give a minimum end of a sentence or a recommendation. And I'm supposed to choose somewhere, well, I don't have to, but within those, but I need to consider them. Anyways, they're going to prepare that scoring. They're also going to make a recommendation as to the sentence. In addition to those guidelines not being mandatory, whatever that recommendation is strictly that. It's a recommendation. They don't work for me. I don't work for them. So the sentencing is up to me. But I still need to have this report. So there are 3 steps involved. Number 1, you're going to get a packet. Now, the clerk has just provided that to Deputy Longstreet, and you're going to complete it and turn it back in. Fill out as much of the information as you can. If you forget something and you need to go get the information or you think about it later, don't worry, because step number 3 will cover that. So step number 2 is you're going to be subject to an interview with an agent from that office, and you have the right to have your attorney present during the time of that interview. And lastly, Ms. Ferravento is going to come meet with you and go over the contents of that report prior to the court giving a sentence. Each side has the right to come back to this court and request corrections, amendments. Maybe there's something you think needs to be changed or that you remembered later on. And so we'll deal with that before sentencing. Do you have any questions about that report?
No, sir.
All right, good enough. Thank you. Ms. Williams, anything further on behalf of the Attorney General's office?
Nothing
All right.
further for the people, Your Honor.
Thank you. Ms. Ferravento.
Thank you, Your Honor. I believe the court might know where I'm going with this already, but would the court be willing to entertain a bond motion today?
I'm not allowed to, well, I would, it really would depend upon the AG's office, but I'm restricted by law that it has to be the 25% of the amounts of the arrears.
We
So
understand that.
I have to leave it set at that. All right. So I will, at this time, leave bond as previously set. If something happens in the meantime, then there's a big payment made, I'm always willing to consider that then. All right, thank you, Ms. Fiervento. Mr. Perkins, thanks for your time today. If you have any questions, please contact Ms. Fiervento. In my experience, she's very easy, quick to respond to questions from clients. All right, thank you all. We are adjourned.